What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hello everyone, this is Peter Schwingler of the Stinson firm. Welcome to this week's podcast of the week. Our topic this week is the persuasive use of exhibits in an antitrust case. And I'm excited today. With me I have Patricia Giannacco, now retired trial attorney with the New York office of the DOJ Antitrust Division. During her 30-year career with the DOJ, Patricia investigated corporate mergers, resale price maintenance, price fixing, bid rigging, market allocation, and fraud, and was involved in prosecutions of antiques dealers, numismatics dealers, waterproofing and roofing contractors, auctioneers, and many others. In 2002, she was awarded the John Marshall Award for Outstanding Legal Achievement in the trial of litigation for her work in United States v. Taubman. Before she was at the division, Patricia was a research attorney in the Connecticut Superior Court Law Clerks Program, and then a clerk to Connecticut Supreme Court Justice Clark Hall. So I'm delighted to have her with me today on behalf of the Antitrust Section's Trial Practice Committee. So Patricia, welcome.
Thank you. I'm glad to be here today too. It's great.
I thought we could start, if you could just explain for the audience what it means to you to use an exhibit persuasively in an antitrust case, and then we can talk about a few different types of exhibits that come up in antitrust cases.
Okay. Actually, I just want to preface what I have to say by saying that, antitrust cases, like many other business cases, involve the introduction of a significant volume of documentary evidence. And it's our job as attorneys to present that evidence in such a way that it is persuasive to the trier of fact and to get the jury to see things our client's way, whether your client is a defendant or the government of the United States or whatever. Exhibits can be persuasive, and they can be persuasive if they're properly admitted and shown to the jury in a way that focuses their attention and connects to related testimony. The important things to remember are that visual presentation engages the attention of the jury. It helps them focus on the information contained in the document. I think it's fair to say that people by and large are visual learners. It's easier for most of us to remember things if we can actually see it or connect it to what we hear people saying. So, just when you're thinking about exhibits and visual presentation, think about how much visual presentation you're engaged in every day. How much time do you spend with screens, whether it be your telephone, whether it be your computer or your TV or a movie, if you're lucky to get out of COVID to go to the movies again. So, but I think you need to keep in mind the jurors are going to hear the stories that the witnesses tell. And the exhibits help to flesh out what the witnesses say and to corroborate their testimony. Among the advantages of documents is that they don't lie. They don't change unless somebody illegitimately changes them. Documents are what they are. It's been my experience that jurors, when they go into their deliberations, want to see documents and they want to hear the related testimony. So they are listening and they are putting it all together.
Can we pause on that point for just 1 second?
Sure.
Because it is true in most, if not all trials, the jury does not get a transcript, but they may have access to the exhibits themselves.
That's right.
In that sense, exhibits have even more value potentially than live testimony. Can you think of any examples from your career where you thought either you or an adversary or a colleague used an exhibit very effectively?
We had in the Taubman trial, for example, we had as witnesses secretaries to Mr. Taubman himself. And one of those secretaries had attended a meeting between the defendant and his one of his employees, in which she wrote down what they were talking about so that he could then go to his competitor to talk about it. Can't say more than that, more about that, but it was a document that the jury asked to see again, and they also asked for a readback of the testimony that was related to it. So in that sense, that was pretty effective.
Yeah, and I also used to be with the Antitrust Division, although I was on the civil side. Mm-hmm. We had a bench trial involving a merger related to health insurance, the Anthem Cigna case, and exhibits in health insurance trials are of, maybe they're not the most compelling or gripping form of evidence, but they can be important. And we had one document in particular. What made it uniquely persuasive was it was directly on point for a key issue in the case, which was the efficiencies defense. And it related directly to a contention that the defendants were making. And in our view, it really called that contention into question. And it was used very effectively. The presenter, the examiner on cross, after this witness testified about the merger efficiencies, did about a 45-minute to an hour cross, and then waited. There was going to be a break, lunch break or something like that, and wrapped it up right before the break, but ended with that exhibit. And so it was fresh on the judge's minds. And it ended up being cited and quoted in the district court opinion, and then the DC Circuit's opinion affirming. Mm-hmm. And so not a jury in that case, but kind of equally important in terms of the ultimate decision makers.
Sure. I mean, the finder of fact is coming to the case that you've been living with for years and years, probably. And, so your use of, even whether it's a bench trial or a jury trial, you're dealing with somebody who's not necessarily on your side, and in fact can't be on your side, is supposed to be neutral. And so you want to be able to take your documents and say, look at this relates to that, and it proves this point. So it does, in my view, it doesn't really matter whether it's a judge, because judges, of course, are more savvy about a lot of things, but some of them aren't. They're learning it for the first time. I don't mean to disparage judges. They're just learning it for the first time. But you point out something very important in getting documents. These are not the most gripping pieces of paper or exhibits you're going to see. I mean, it's not like a videotape at a bank robbery, where lots of things are going on. So there is always potential for the jurors to get a little snoozy and sleepy. So I think that in order to counter that, you really need to plan very carefully about what you're going to present to the jury. You have to be, and part of that is, you're here's your witness. What part of the story is your witness going to tell? And typically in antitrust cases, you don't just have one witness who's going to tell the whole story. You usually have a jigsaw puzzle. So you need to put together what each of the witnesses says and present documents through them, which illuminate their testimony. So you need to be very selective about your witnesses, and you need to be selective about what documents you're going to put in through them. My advice would be, compile your top 10, 20, 50, however many documents you think you're going to need to make your case. And then narrow it down. What are the key or essential documents? Sometimes less is more. What are the documents you're going to need to establish your legal theory? What are you going to need to establish your factual theory? Is this document going to confuse or enlighten the fact finder? Is the testimony going to help to explain it? So if on its face it is somewhat confusing, will it suddenly make it clear? Will not using an exhibit that you have, will that subject you to an accusation that you're hiding the ball? And maybe you want to get in front of that if that document is not particularly helpful to you. Both sides have the documents that, it's not as if you have secret information that you're going to present. Everybody except the jury is aware of what there is. And when you're on, you're exchanging exhibit lists and so on and so forth. So each side knows what's happening, as well as the judge. And one way to make a document or a group of documents persuasive is let the witness tell the story. Let the witness tell the story. Find out from the witness, for instance, if you have a price fixing case or even a bid rigging case, what documents did you use to arrive at your price that you used? What documents did you use to tell you who you were not going to bid against? And let the jury hear that story. And then once the story is told, then use the documents to basically retell the story. Because for instance, in bid rigging cases, especially where you have bids to public authorities, the bids of the other bidders are known, and sometimes there are bid histories that are kept. So, I mean, even just as a business record, not necessarily for the purpose of the bid rigging per se, it might be part of that, might be used for that purpose. But the witness may say, "Well, I was going to bid on such and such an account, but I wanted to see who else bid. And so I had these bid histories, and they show me who bid, how much they bid, over what period of time, et cetera, et cetera." And by the time the jury, you introduce the record, the jury is, I heard testimony that explained that to me. And then you go through it item by item. The most persuasive thing you can do with a document is actually use the document. It's great to get the document in. If you're a young attorney, it's really wonderful. Yes, that's admitted, fine. But then, you don't just say hooray and sit down. There you go over with the witness. What does this document really say? And frankly, nobody knows the documents better than the witnesses because they've been working with them. So in your trial prep, I think it's very important to go over in detail what your witness is going to be able to say about this particular document, so you're not blindsided at trial. So.
How important is the sequencing of the exhibits and the witnesses at trial? One thing that I think a lot of folks struggle with is you've got a document that touches multiple witnesses, right? An email from one person to three other people. Right. And maybe two or three of them will be witnesses, and they'll be called at different times. And, the document might be better to use with one of the witnesses than the others, but it might make more sense at a different, time in the case in terms of the storyline. How do you go about prioritizing, which documents to use with which witnesses?
Well, a lot of the time, one witness can shed more light on something. I mean, so often emails are between A and B might be the defendant. So you're not going to have a lot of people to talk about it. But there's nothing that precludes you from using the same document with another witness to fill in a blank. I mean, you really have to make these assessments before you actually get into a courtroom and figure out who's going to give you the best bang for your buck with this particular document, who created the document. I mean, you can testify about a document that wasn't created by you if you have knowledge of the document, or whatever other exhibit you might have. But it helps sometimes to know who created it, why they created it, and what they were trying to get across. And very often, as I said, you will have an email from A to B. It may CC a number of people, but A to B can give you the starter. That would be my gut. I mean, that could be different. I don't know. What's your experience been?
Well, what I find, especially for younger attorneys, and when they're, before you have the trial, at least in the civil case, you have the depositions, and so you have a few different rounds of analyzing potential documents, and you can test them out in the depositions and see what works. But whether it's a depo exhibit or a trial exhibit, not all pieces of paper are created equal. And not all versions of the same document are created equal. So what I always like, especially in the day and age where most documents are going to be emails or attachments, even if somebody created a PowerPoint, saved it on their hard drive, is when they emailed the final version to their assistant to print before the presentation or to the CEO of their company, right? That version with the transmittal email that gives context, it's infinitely more effective if you're deposing someone. If you can say, this is the final version, this is what you showed the customer, this is what you showed your boss, then it could be a draft and they might be able to run from it. And I don't know but usually by the time you get to trial, you've probably culled things down to where you're mostly relying on things that are sort of the best version of the documents. But it's kind of a flip side, is related issue to picking which witness covers which document is, where will you get the most bang for your buck? And sometimes you can have a document that's great on a couple of points. It hits four things you care about, but you have one other document that hits one of those points much better. Mm-hmm. And you may not have time to use both. So I think the art is really determining which documents get you the most bang for your buck, which can involve trade-offs.
Mm-hmm. That's it's important, especially when you're a young attorney, not to get married to, particular evidence. You think this looks fabulous, and it would really be great. But in the grand scheme of things, and trying to create, the world for the jurors to step into, to see the case your way, that particular document might not be so great. So, or there might be something better. It might be good, but there might be something better. I mean, there are limitations on what you can do. It's in terms of time. Yeah.
So one thing I wanted to talk about for purposes of this podcast, because I think it's possibly the most important type of exhibit in contemporary antitrust cases, is the business exception, records exception to the hearsay rule.
Right.
And so it's great to have a document. It's great if it says everything you want it to say. It's not so great if the judge says, I'm not admitting it into the record. Right. So could you talk a little bit about, maybe give a little background on what that exception to the hearsay rule means, how it plays out in practice, and then some pointers for how folks can use it effectively at trial?
Sure. Well, as everybody knows, hearsay is an out-of-court statement offered for the truth of its content, and it's inadmissible. However, and the reason for that is that the trier can't know what weight to give hearsay statements, whether they're in writing or whether they are oral. But the business records exception, and among others, they're not hearsay. And the reason they're not hearsay is because they have indicia of reliability. Business records, or records of a regularly conducted activity, which is the way the evidence rules state it, they are made for a business purpose as part of an ongoing business, and they need to be reliable for the people who are using them every single day. They need to be reliable for the truth and accuracy of the information that's contained in them. So for that reason, they are more reliable than many other kinds of documents, many other kinds of statements. I mean, for instance, not only business records, things like recorded recollection, statements for medical diagnosis, the kinds of statements that have more reliability than just so-and-so told me thus and so. There are ways to establish that a record is a business record. Of course, you always need a witness with knowledge under Rule 602 of the Rules of Evidence. And that witness really needs to satisfy a number of criteria for you. A business record has to have been made at or near the time of the event it memorializes, or it has to be made from information transmitted by someone with knowledge. The record has to have been kept in the course of a regularly conducted business activity, and the making of the record was a regular practice of that business activity. And all of these conditions can be established by the testimony of a custodian or another qualified witness. So if you have a fact witness who talks about using these documents on a regular basis and perhaps even creates them or has to rely on them by the work of other people, that person can show the trustworthiness of the document, and more often than not, the judge will allow those in. So that's the essentials of the business records exception. Is there anything you want to add to that?
Yeah, I'm just curious, in your perspective, given that you're recently retired, and during the course of your career, you've seen, the advent of email, and a trial from early in your career probably looks very different from a trial today in terms of the nature of the documents. Mm-hmm. And I know, the circumstances under which emails are considered business records is hotly debated and may depend on whether you represent a plaintiff or a defendant. But clearly, this exception to the rule, at least at its inception, had something to do with, real records, things businesses were doing that they were relying on for business purposes, where you had to be accurate, right? If you're writing down your sales prices and your transactions, that goes into your accounting software. Like, a lot follows from that. So there's that indicia of reliability. I send 100 emails a day where I'm just firing stuff off at the hip, right? And so in a conspiracy case, oftentimes emails are admitted for non-hearsay purposes. Yeah. But you do see there's a lot of effort to get emails in under the business records exception. Is there any advice you have to practitioners about sort of strategies or best practices for identifying when an email is a good candidate as a business record?
Well, very often you have, businesses do so much through email these days. I mean, they're providing information to their customers and, within the company and talking about strategy and so on and so forth. But they're also attaching materials to them, yes, which clearly come under the business records exception, and the transmission of that, I think most judges would agree that the email goes with it as well. So one of the things you want to look for is, we always want to look at what the business purpose is, and what's being conveyed in the email, what's the information that's in the email, because the reason it's an exception to the hearsay rule is that you can rely on the information that's in it. So I think, you're right. Documents, the kinds of stuff we saw years and years ago is very different from what we see now. And of course, when you're receiving documents in discovery and during grand jury investigation, there are so many more of those documents than there used to be. So, you figure out what your search terms are as you're going through the electronic productions that you'll be getting. What are the business, what are the business purposes of these documents? Now, very often business documents are used for a nefarious purpose as well. In the when I mentioned earlier the bid histories. I mean, that's a nice guide for somebody who wants to gauge their pricing in order to either win something or avoid winning something. In accordance with whatever the conspiracy is, but they are typically business records as well, so you'll be able to get it in that way. But think about who will guide you. Your witnesses will guide you. They will tell you what business records are. They will tell you what kinds of documents they use to rely on, and and how they relied on them for both legitimate and illegitimate purposes. So I think that.
Well, and that's everything kind of comes back to the witness, right? I mean, it's very hard to try a case that is only documents without a human to tell the story.
I would shudder to see that case. Old documents all the time.
So we have one last topic that we can cover briefly, just because it doesn't require too much discussion, but it's important, and that is the use of summary exhibits. Mm-hmm. And perhaps you could share some insights into how one can effectively use a summary exhibit at trial.
Yeah, I can give you an example. In one of our cases years ago, we had it was bid rigging case, and there were multiple telephone calls that took place between the conspirators very close to the date of the bid. And of course, you're not going to ask a jury to sit through while you go through loads and loads of telephone records. But you can have the witness, again, it all goes back to the witness. You have the witness tell the story. We hardly talk to each other unless there was a bid coming up, and then there would be this flurry of activity. And you can have a paralegal, for example, pull together the telephone records for each of the conspirators and show on a chart where there were spikes in conversations. And the key to that being an effective exhibit is that you have had testimony from a witness who tells you how that works. And now here's the visual representation of how that works. And that to me is a good way to put it together. If you're going to just put in a summary exhibit showing, prices or whatever, without that, again, without the witness giving you the guideposts to how to actually read it. Now, the witness will not have usually created the summary exhibit. Occasionally there are, again, these bid histories, though, I guess you could say are summary exhibits, but they're created by the witness, but that's not usually what you have. Usually you have telephone calls, or you have pricing spikes, or, that kind of thing. And again, it's all dovetailing into the story that your witnesses have told. So, with witnesses, don't rely on one witness. Always have a plan B. Hope you have more than one witness who can tell the same story. I mean, after all, they're unless you've got a one witness case, which is always a dicey proposition, you usually have more than one witness who can explain what the conspiracy was about, how it was done. You have situations where one witness has been the boss of another witness, and they explain how they taught that other witness how to do it. So it's again, it's weaving a story. You want to keep the jury engaged, and create your foundation. Tell the jury what you're going to show them, and then show it to them. Use your witness for that, and then you can use your summary exhibit for the visual impact.
Well, that is sound advice if I've ever heard it. And we're running up on the edge of our time, so I guess I'll let you have the last word, Patricia. Before I do, though, I want to thank you for joining us today and imparting some wisdom. And I think a good way to end it would be, if there's any one piece of advice you'd have for younger practitioners who are thinking about their first trial, what would the one thing you would sort of highlight for them? What would that be?
In terms of, before you ever set foot in the courtroom, prep. You'll be prepping your witness. You will have your outlines. You will know what you want to ask, and you need to anticipate what the objections are going to be. And there's just no substitute for that. And for young attorneys, always talk to those who've been around for a little longer, because they will help you and guide you, and they want to see you succeed. So good luck to you all.
Absolutely. All right. Well, thank you everyone for listening. Thank you, Patricia, and we'll call it a day.
Okay. Thanks, Pete.
We hope you enjoyed this episode of Trust in Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.